CCMA has.
I've heard that before.
Yeah.
That all they want is just to make sure that they settle the case, then it's over.
Then it's over, yeah. As an experienced and a seasoned professional in labor relations.
Yes.
So you having loads of money throughout that process, which may not even end at the CCMA. It might a lot of costs attached to preparation, but obviously preparation is key because you need to be confident in your case. You need to be entire process. Let the process unfold. When you are invited by the commissioner to enter into conciliation and attempt to find each other,
many HR leaders and managers believe that you have to win and fight each and every single CCMA case you have. Today we are here to explore whether that is true or maybe that might be expecting too much from people that are working for a company that has to be both profitable and reputable in the society. And some people believe that winning a case shows that you are a strong labor relation professional, and settling a case in the CCMA shows weakness. We don't know whether that is true or that is just expecting the impossible in a human world. I'm your host, Solomon Makgobatlou, the CEO and founder of Sisol Holdings, and thank you for joining us. I'm here today with Mr. Sifiso Dlungele, an expert in labor relations and an LLB graduate from the University of KwaZulu-Natal. I will not be the one doing too much of the introduction. I'd like him to tell us. Sifiso, welcome again. Thank you very much for joining us.
Thank you for having me.
Definitely, we are super excited to have you here. Can you please just tell our viewers and our listeners about who you are, what you do, and all that?
All right. Thanks once again for having me. As the host, Mr. Makgobatlou, has already mentioned, I am Sifiso Dlungele from the not so busy town of Durban. I have attended the University of KwaZulu-Natal in furtherance of my legal studies, studying a Bachelor of Laws. And today I specialized in labor relations, as I found a lot of interest and love for this field or avenue of the law.
I'm just curious, Sifiso. You know, some people they go to to the streets and look for cases, taking people out of jail, fighting divorces. You just chose labor. Where did you get this interest?
Well, it's a crazy story.
We love crazy stories.
Yeah. So I've actually been in this is the workforce talk. So I've been in the workforce industry for quite some years, even before becoming a professional. So during my high school years, I think about in grade 10, if not 11, I was working at a restaurant. Not far from my home and my high school. It's really not much of a restaurant, but a fast food outlet, which is Roman's Pizza. But nothing crazy happened there. Just giving you a background of when I started working. But my father wasn't really happy with that, working at a young age. But I was a bit forward. But it's good. It built me and so forth.
Managed to hustle.
Yes. So fast tracking to about 2016, I was doing my second year at the University of KwaZulu-Natal at the Peter Maritzburg campus. So during the festive season or even school recess, I would go and work for the Foschini group at Sports Scene.
I must mention we're not promoting for that
yes,
brand, right?
yeah. Yeah, I just want to give you a clearer background of how the retail industry is and how tough it could get. Yes. So yes, I was working in Durban CBD at Sports Scene, and there were things I would pick up as a general laborer or a franchiser, so to say, that there wasn't much of a relationship between what you would call a team leader or supervisor or a line manager with the general workforce, and even an incident that once transpired whereby there was a loss of a box of SIM cards because Sports Scene also sells cell phones. So the manager then decided to because she couldn't really identify the primary perpetrator. So she decided to discipline everyone who was on shift that particular day. So
everybody.
Yes, everybody. So
very risky strategy.
Yeah. So at that time, obviously, it was my early years of my degree. So we would be studying an overall of the legal profession and your criminal laws and so forth. It was only the following year where we were then doing labor law, and then I was learning more about it. I was learning more about the basic conditions, the Labor Relations Act, retrenchments and so forth. And that's when I really grew an interest in wanting to know, was that procedure that this manager of mine in the previous year followed properly? And obviously I ended up getting a distinction in that module because of, I was quite intrigued. Thank you. So I think that's where it all started, the love for this field of the law.
I must also mention that most people don't know much about this field of law. I, for one, I also had to find out from one of the guys that used to work at the university that I attended, University of Witwatersrand, Wits University, for those that know it by Wits.
Wits Edge.
So I really didn't know this, and I asked him, dude, what do you really do? I mean, what do you do on a daily basis? Because I always see you walking around the campus. I'm used to know, when you hear somebody saying that I'm at work, I'm working, they must always be busy, like behind the computer and all that. Then I saw this is something different, This person is just enjoying their life and doing what they like, and he looks happy. He looked very happy at that time. And I must mention Clifford Chauke, which is a very good friend of mine and a mentor and a coach. But I mean, to think about the fact that you started working a year prior, you could actually do the module. Then later you realize that, this is actually what happened.
Yes.
And probably this is what I should have done. And how did that make you feel when you finally, study labor law and realize that maybe there was something to answer from your previous employer? How did you feel about it?
Well, maybe at the time, because of my age, I would say I felt, empowered. But obviously, you need to be, careful when you think you know too much, and then you start answering things in a way that might not be appropriate or legally correct. Obviously, after your law degree, you'd have to undergo extensive training to actually know the
Yes.
correct application of the law
Yes.
and when to take action and when not to. Yeah, but to answer your question, at that time, I felt like, yeah, no, I have the tools now. So if someone comes at me
Yeah.
from that angle, this is what I'd probably say. Yeah.
So, today's topic, I want us to focus on whether, like I mentioned when we started talking, on whether settling a case in the CCMA is a sign of weakness or it's wisdom. You know, you mentioned now that it's not just about the qualification that you have. You still have to go do your practicals so that you can learn as to, you know, when to fight and when not to fight. So, I'm sure you lost count how many times you went to the CCMA. Can you maybe explain to us how I'm an employee, or I'm an employer, an employee goes to CCMA, refers me to the CCMA to come and answer, become a respondent. Where does the process normally start? Let's get out of the workplace. Dismissal is done. We are in the CCMA.
Yes. So, yes, in an instance where an employee has been dismissed, they do have the right to refer a matter to the CCMA
Yes.
on the grounds of unfair dismissal. So, when the matter is set down for hearing at the CCMA, there are a few processes that actually starts before we get to deciding whether the dismissal was fair or unfair. So we would get a process called conciliation.
Yes.
Or a process called con-arb, which is a conciliation, and immediately thereafter there would be an arbitration. So the employer, which is yourself, would then, once receiving a notice of sit down for a conciliation / arbitration, you also have the right to object to arbitration proceeding immediately after conciliation.
Okay.
Right. So when you get to the CCMA, the only process that will be dealt with is conciliation.
Okay. That's exactly the kind of process that I would like us to actually talk about today.
Yes.
You know, because our topic, it actually covers about the conciliation part. So with regards to conciliation, most companies believe that when you go to CCMA, you must, if you've dismissed somebody and you go to CCMA, you must go and win that case. Where do you think that this kind of mindset really comes from?
Well, perhaps it comes from exactly that you need to stand by your initial decision that you have taken. You have decided to dismiss this person, and if they take you to an external dispute resolution forum, CCMA or a bargaining council, you're there to fight. You're not backing from your initial decision.
Yeah.
So I think that's where the idea comes from, that if you go there and you sort of try to negotiate with the employee and you try to pay them off.
Yes,
in a sense.
It sounds like that.
Yeah, it sounds like that.
Yeah.
Then that's where the weakness connotation comes from in terms of settling a matter.
But do you really think that I'm of the view that the fact that there is this process that is governed in law that requires that before we could actually arbitrate, parties need to sit down and actually talk and see if they are amenable to resolving the issue before they fight. I don't know if does that say that maybe the CCMA or the bargaining councils, all they want is to just get the case settled without fight. And I'm just wondering as to where does this ideology of settling the case becomes actually seen as weakness. Yeah.
No, maybe we can start at what the primary objective or goal of the CCMA or bodies such as the CCMA.
Let's start there.
Yeah. So the CCMA it's a dispute resolution forum, which is aimed at resolving issues between the employer and the employee in an amicable manner and in a expeditious manner as well. That's also another key factor in terms of their dispute resolution processes. However, people may misinterpret this to mean that they're just trying to get work off of their table and clear their CCMA roles, so to say, because obviously everyone knows that the CCMA has...
I've heard that before.
Yeah.
That all they want is just to make sure that they settle the case, then it's over.
Then it's over, yeah. Yeah, so people have that idea that they are trying to clear their backlog and, you know, they are inundated with cases, that is a fact, but then in them expeditiously and amicably allowing the parties to find each other and there be a meeting of the minds.
Yes.
It's not that. It's not that they're trying to...
I see.
To not give justice to the parties. Remember, there must be a balance between the employer and the employee in terms of fairness.
Speaking of that, sorry, you mentioned something earlier, that some people would want to go to CCMA, fight and stick to the decision that they made.
Yes.
In-house.
Yes.
Now, you get to CCMA and you are required to conciliate. Yeah, I think that's the right word that I was looking for.
Yes.
Then you are required to conciliate. It's not whether you are, you can decide whether that process you're going to skip or not. You are required to go through that process. You might sit there and keep quiet or maybe say, I don't want to participate. But it's part and parcel of the CCMA process that is governed in the law.
Yes.
That at least there must be a trial, you know, of the parties to see if there could be that meeting of the minds.
Yes.
So when you leave your office, go into the CCMA and you know that you fired this person, they did 1, 2, 3, 4, 5, and you believe that you have a strong case. I'm just wondering as to how that appears to the decision makers. Because one of the things actually which I think we need to talk about is, you spoke about a chairperson who makes a decision, who has to stick to the decision they made. But however, with my experience, chairpersons do not make decisions. They make recommendations. Can we talk about that?
Yes, that's correct. Chairpersons don't make the final decision.
Yeah.
So, they make recommendations, and it is the executive members that then act on the recommendations of the chairperson and make the final decision to apply the sanction on the employee. It doesn't always have to be a dismissal. It could be a written warning or a final written warning.
Yes.
But that imposition of the sanction is actually done by the executive.
But normally, do these executives attend the CCMA cases?
No, they do not. They do not.
Yeah.
Yeah, but the chairperson is a decision maker in as far as the guilty verdict is concerned. So the chairperson will make a finding of guilt.
Yes.
And once the employee is found guilty, then the chairperson will allow the employee to give mitigating factors, will allow the employer to give aggravating factors, to sort of persuade the chairperson to arrive at whichsoever appropriate sanction in the circumstances, and then recommend to the company or the employer that this is the appropriate sanction to impose on the employee. So that's where the difference is.
Because I'm thinking from a perspective of a HR or ER manager, officer, specialist, whatever, whatever the position might be, working under in a company where there is probably directors and HR directors, but this person is responsible to make sure that they chair the hearing, they issue the outcomes, and also they go to the CCMA or the bargaining council to go and represent the company. Yeah, I think that's the right word, not fighting. They go and represent the company.
I agree, that's the right word.
Yeah, because I think we in this profession, most people believe that we go and fight because that's how we normally talk. That, I'm going to fight this case, But that's not what the CCMA is made for. I don't know if you agree with me on that.
Yes, no, definitely. As I said, the CCMA tries by all means to have the parties find each other and resolve the matter in a way that is fair for both the employee and the employer. Yes.
So what internal pressures do HR leaders face when deciding to settle cases normally?
Well,
I'm just speaking from, I want you to speak from experience, from what you deal with on a daily basis when you talk to your clients about their cases, when you probably engage to see if there is possibility of settlement.
yeah, so when you find yourself in a position where you feel that there is a possibility of settlement, and you go and you pitch this to the clients or to the board if you're an in-house specialist, the obvious challenge that you that you may come across is rejection. So where you don't get mandates to settle, it gets a bit frustrating. But I don't believe that it should in any way be a hindering factor on your confidence of the manner in which you're going to present the matter at the CCMA. But obviously it's a matter of experience and how your negotiating skills have
very important
have actually developed throughout the years as an experienced and a seasoned professional in labor relations.
Yes.
So you have to get to the CCMA and actually gauge the feeling and the mood and know the right questions to ask and know the right answers to give when asked by the commissioner what the company has on the table for the employee.
But going back to the decision that you made a decision to dismiss, the case is referred to the CCMA, you must now stick with that decision. Now, I remember I found myself in a position many years ago while I was still in the employment of another company, one of the biggest companies in South Africa, where I had to go and represent the company in the CCMA. And my problem was, I just joined the company. 2 days down the line, I had to go and represent the company in the CCMA. The company and the previous chairperson made the decision to dismiss. Now here I am. Here I am coming to this case. I don't know how the case was done. I had to prepare using the documentation that was there. And the mandate was, there's no mandate. We do not settle here. You go and fight it.
Yes.
I'm just wondering, how do we expect, as business leaders, how do we expect ER specialists to go to CCMA, go win a case, fight, not represent the company, fight and win the case, and when you lose, then it means they made the wrong hire. Do you believe that is fair?
I don't believe that it's fair, and I don't want to have your general response to say it's part of the job.
Yes, yes.
And you just have to do it. You just have to make it happen, because that's the expectation.
That is
right?
the expectation.
Yeah.
That was the expectation for me. That you said you can, you said you will, then go do it.
Yes. Look, it's easier said than done, but you need to be bold, and leaders of these big organizations, or any organization, need to understand that I made this hire on merit, and I need to understand the role of any HR personnel within the business. But if we want to be specific and speak to an employee relations personnel, leaders need to understand what role employee relations specialists play in the organization.
Very important.
And it's mostly on advisory, because you need to trust that your specialist, which you have hired within the company, or a specialist that you have outsourced, a service provider such as Sisol labor projects and so forth, to give you the best possible advice when dealing with issues of employment or workplace discipline, incapacities, and the likes. That your specialist will tell you the prospects of success of a case, and will tell you and give you a rundown on the risks attached to those prospects, the cost analysis, and just the overall of the entire case. So you have to make the call.
Yeah.
And you have to be bold enough to tell your superiors that this is the situation. This is how much we could save if we opt for settling. And that's a duty that's upon you as a professional to give the best possible advice and ensure that the best interests of your superiors, your employer, or the best interests of your clients are at heart.
Very well summed up. I actually like how you put it, that you, as leaders in HR or labor relation, we need to understand that our job is not just to take instructions, but it's advisory. We advise. If your advice is not taken, then you have problems ahead. Then it's what you've done. You've done what you were supposed to do. Being brave,
yes,
being bold, and saying what you believe is right.
Yes.
As a internal consultant or even external consultant.
Yes.
So I want to move to the next question here that I'm very much interested in, and also looking at your career path and what you studied. What would you say is the difference between a legal victory? I can tell you what is a business victory, but I want the difference between legal victory and business victory. And from my perspective,
yes,
when we talk about business victory, as a leader of Sisol Holdings, I can tell you, if I go to CCMA today, I would like to have either I get an outcome that says it's in my favor as a business, Or I save money on, number one, paying for the legal costs or the cost of the representatives. I mean, there are many businesses that do not have labor relations managers or specialists in-house.
Yes.
They will have to go outside and consult and get consultants or get law firms
Yes.
to actually help them with their cases. So when it comes to that, knowing that I'm going to spend hundreds of thousands or millions on attorneys, whom I also believe that, they charge per hour.
Yeah.
Each and every hour of fight is a cost.
Yes.
I'd rather settle the case, save my company the stress, save the money, save the time. But secondly, for business, a business victory would also mean that my resources, my employees are at work, they are working, they're not sitting in the CCMA for days, weeks, months, but they are producing and helping make the business sustainable. I don't know if you want to comment on that.
Yes. So, yeah, maybe if we do deal with what a legal victory is.
Yes.
In the strict sense of the word, is obviously, as you've mentioned, it is receiving an outcome that is in your favor.
Yeah.
Right?
Yeah.
Be it a judgment or a ruling, which is made by the presiding officer in your favor, after a lengthy and tedious legal battle, be it
And expensive.
and expensive.
Can we not forget that it's expensive?
Yes. So, yeah, that would be a legal victory in that sense, and perhaps even with the costs involved, because legal fees could really cost an arm and a leg. And if you were able to argue for costs to be paid to the winning litigant, that is quite a victory, especially for your principles in a law practice or a law firm. I think sometimes, though, it yields more towards that factor more than actually winning the case on substance. However, when we speak on a business victory, I must agree with you to say that if you are able to ensure that you can still maintain and uphold meaningful and efficient and productive operations of your organization without having to go the whole 9 yards in terms of a dispute resolution at the CCMA and spending loads of money throughout that process, which may not even end at the CCMA. It might even go on review at the labor courts. It might go on appeal at the labor appeal courts. It could be endless. There are decisions, executive decisions that need to be made at a very early stage to ensure that your business continues without any hassles and so forth.
I think we also need to remember that a business is not one person. A business is a collective of people. So we need that, as leaders, we need to make sure that we understand that whatever decisions that we make, they do not only affect one person, they could affect 1,000 or more, depending on how many people you hire. So I want to get, just to understand your mindset around, strategy with regards to making a strategic decision to make a settlement. So when is settlement the right strategic decision?
Well, the long and short of it And the obvious answer would be if the prospects are quite slim. If the prospects of success are quite slim, then obviously that would be your red flag to say, okay, we need to consider these options. We need to.
But what would really make the prospects to be slim, like you are saying right now?
Look, procedure is key in all processes surrounding workplace discipline and employee relations.
Yes.
If you can detect from the reading of the record of proceedings, the internal record of proceedings, from your suspension to your investigation, whether the suspension was precautionary, whether the suspension was with or without pay, going on to the investigation, going to the disciplinary inquiry, which is an extension of the investigation. If there are any issues which you can pick up from your reading of the record and from your consultations with your superiors or your consultation with your clients, you need to start having these discussions around settlements.
Yes.
And it doesn't always have to be monetary. It can always be an instance of, if it's not too late, we can redo and restart the process and make sure everything is done properly.
Yes.
I mean, there are instances at the CCMA where the commissioner would say, no, the employee is guilty of a known workplace rule. The employee has contravened a known workplace rule.
Yes.
But the process wasn't followed. So take this person back and do the right thing. And maybe I'll see you guys next time. So
then you still have the opportunity to actually, control the narrative.
Yes.
So you mentioned two things that are very important, two critical things that I want our listeners and our viewers to really understand. You said, number one, that settlement does not mean that you have to settle monetarily. You have to spend money. That's what you said.
Yes.
And you also said that you also have an opportunity to go back and correct. If there were any procedural errors, you still have an opportunity to go back, reinstate, go back and redo what you did.
Yes.
Because either way, reinstatement simply means that everything that transpired before is reinstated back.
Yes.
Everything goes back to where it was. We don't start afresh. So let's talk to non-monetary settlement. Because even if you were to go now to the CCMA or the Bargaining Council, you will meet people who are saying, you know what, we are not going to settle. We are not prepared for that. Our company does not settle.
Yeah.
And most of the time, this comes from a place where people think that to settle a case, you need to have monetary mandate.
Yes.
But just to get, I'm of the view that if you have a mandate to say, you know what, you can explore the possibilities of settlement.
Yes.
But you are not saying that you can go and spend my money. Here's a blank check. Because that's what most executives and most business leaders believe, that when you talk about settlement, you talk about that. Can you give us examples of non-monetary settlements that are available?
Yes. Yeah, no, I agree with that. And maybe this idea manifested over the years. Maybe you may find that there are executives that have been present at the CCMA, and I don't want to speak ill of anyone or any organization or body, but like we've been saying, the duty of the CCMA, which extends on to the commissioners, is to facilitates a dispute resolution process, and the first step is obviously conciliating.
Yes.
But this conciliation must arise from an agreement between the parties, and the commissioner is to act on that agreement. The commissioner cannot enter the arena and try to say, "Oh, come on, 1 week, nyan," you know.
But they do that.
They do that, but
They do that.
Their duty is limited insofar as facilitation of the processes.
But I think it's just to get the parties to feel engaged, and also to try to persuade and test the waters.
Test the waters, yes. No,
yeah.
I agree.
I'd come to that defense day.
Yes. no, that I take that. But at the end of the day, the parties must reach an agreement.
Yes.
And that is what is to be recorded on the settlement agreement.
Yes.
By the commissioner, and the parties sign and they part ways. So you may find an offer that is tendered by the employer to say, no, look, we can reinstate, but we are not giving the employee any back pay.
Yes.
The commissioner will come in, and obviously there are instances where the commissioner would look at the fairness now of
Yes.
why is the employer not offering back pay. There's a lot of considerations to be made, and factors. Maybe the length of from the time of dismissal up until the CCMA conciliation.
Yes.
The commissioner is within his rights to, as you say, test the waters and actually try to dabble in that space to say, look, can you not consider
Yes.
giving this person back pay because they have been sitting at home for quite some time? But there are instances where if it's not a considerably long length of sitting at home, where you'd find that the commissioner will allow that and the parties would agree, and the person is then reinstated. Other instances where you can settle without the use of money.
So you're saying you can actually negotiate your way to reinstatement without retrospectively paying this person?
Yes.
Oh,
Yes.
that's interesting. That's interesting.
So
therefore it just makes conciliation a process where you're able to put anything that you have before the commissioner.
yes, it all boils down to what the parties agree on, and if the parties agree, then you act on that agreement.
That's a nugget.
Yes. So yeah, another example perhaps would be tendering a neutral reference for the employee
Yes.
to, it's a gratuitous gesture to say that, look, we won't give you a negative reference. The reference will be neutral to say that you've been working for the company for so many years or so many months, whatever the case may be, and you can at least secure future employments elsewhere, and
Which is very important.
Yes.
Yeah, I think that is really. It's also helpful. I mean, I've obviously when employers hire people, they have to go through the process of reference checks. So, I mean, I'm sure some of the listeners and people that are watching our channel would be employees. So it's those things are very critical.
Yes.
Having a reference. I mean, one of our business is Sisol recruitment, where we recruit, and one of the work that we do is to make sure that we check the references. And if references say something negative, you might find out that the client would say, I don't want a person that got fired. I don't want this, I don't want that. I mean, imagine if somebody was fired for stealing a sweet in the store. This is like a one-rand thing, but you get dismissed for stealing a sweet because of the principle and the policies. And then that offer, you refuse it, and you go and fight and lose the case, then automatically the experience that you had in a company, you might not even put it in your CV because you're scared of the reference that might be, given.
Detrimental to
But anyways, going back to the settlement, I just want to get this one. What would be the hidden costs of fighting a fully fledged case? I'm not saying representing the company. I'm saying fighting. What would be the hidden costs around that? A lot of people right now, obviously would be thinking that, number one, I have to pay for my attorneys. Number two, I have to pay for the employees that are off from work, and also account for the production loss for the day. But I'm sure there are other hidden costs of fighting and just avoiding settlement altogether.
Yes, so as I mentioned previously, and you've also mentioned it now, that there are costs surrounding having to spend days at the CCMA. So your production obviously gets affected. Your specialists that you have sent out to the CCMA, their work stops because they are at the CCMA the entire day or for a couple of days. Or if you have appointed a firm of attorneys or a labor law consultant, those are the obvious costs that you will have to account for. As opposed to settling the matter at conciliation or at the earliest possible stage, because you can even settle before the matter is set down for hearing.
I mean, for me as an entrepreneur and a CEO, I think the biggest thing is having my employees in good mindset, for the lack of a better word. I wouldn't want, because I've seen managers a few days before they can even go to CCMA, they are already scared of the fact that they are going to be cross-examined. I mean, I remember one of the cases where there was this very strong advocate.
Yeah.
I had to prepare, me and my team, we had to prepare the witnesses 2 weeks in advance, and even a week before, we even had to go and re-prepare them because they were like, we're not sure what these people are going to ask.
Yes.
And this attorney or this advocate is like, he'll grill you for the full day.
Yeah.
Right? So I think for me, that is also one of the hidden costs that I think maybe a lot of people don't look at.
Yes. Preparation.
Exactly.
Yeah.
Oh, also preparation costs.
Yes.
Indeed.
There's a lot of costs attached to preparation, but obviously preparation is key because you need to be confident in your case. You need to be confident in the rules, as you say that they were afraid. Managers were afraid of cross-examination.
Of course.
So you, as the person that's going to be presenting the case on behalf of the company, you need to be confident in the rules of evidence and actually try and object to any unfair questions that may be coming your witness's way. Yeah, so preparation costs, very, very huge factor.
No, I fully agree. So how should companies calculate commercial versus legal risk? Because I don't think that you do a case and then go to CCMA all the time. You're always willing to give money. You just obviously, for me, that would have a negative impact on the reputation of the company. Number one, it can also have a negative reputation of it will send a wrong message to the employees, who are always, if an employee is looking for 3 months compensation, they know the company always settles for 3 months because people talk.
Yes.
Then it goes out there, then everybody knows that company X, they always settle. Obviously, I don't think that will be a right thing to do, and it will be it will defeat the reason why we have employee relations specialists in house, or consultants like ourselves, you know. But how should companies calculate this commercial and financial risks when they go and make a decision as to whether they're going to settle or they're going to fight? I'm going to use the word fight.
Well, we don't want to, as ER specialists, to create dangerous precedents in the workplace.
Yes.
We don't want organizations to be known to easily give in.
Yes.
Or and settle matters even when there are prospects and there are grounds for dismissal.
Yes.
And when you are confident enough that the sanction which was imposed was proportionate to the misconducts, then there's absolutely no reason for you to easily give in, unless, of course, you weigh or you do an analysis of how long the case is going to take, as opposed to settling it at a much lower compensation. But going back to the setting of a dangerous precedent, employees mustn't believe that compensation is for the taking. There must be talks about talks. There must be negotiations.
Most employees, and I'm glad we have this podcast.
Yes.
And we're talking about this topic because we could actually teach other employees. I once had a case where an employee came and he was asked, "What's your ask?" And the guy asked for R1 million. And this guy was earning about 7,000 to 8,000 rands per month. But he asked for R1 million. And the question the commissioner asked was, "Where do you get that number?" He couldn't answer.
Yes.
So I actually like that.
Yeah, and commissioners really do frown upon that in most instances. Perhaps where there is an offer on the table on part of the employer to say that, look, we can take you back, but the employee says, no, I just want money. I don't want to go back there. So commissioners tend to frown upon that because the employer is giving you another chance to come back and prove yourself or correct your behavior if indeed you were found guilty of doing whatsoever. So yeah, compensation is absolutely not for the taking. It's something that needs to be agreed upon. Yeah. But going back to your previous question, there must be consistency in the application of discipline in any workplace. So the commercial implications may be that if you don't take action on, let's perhaps say we spoke earlier about absenteeism or poor timekeeping, late coming and so forth. If you find yourself in a situation where you had dismissed someone for habitual late coming and you had undergone all progressive discipline methods and corrective discipline methods in attempts to correct this employee's behavior, and it ends up in a dismissal. And when you get to the CCMA, you pay the employee off or you reinstate. It creates in the workforce climate a sort of, I can do this too, and when I get to the CCMA I'm going to come back to work, or I'm going to get a payout.
Definitely.
And that's not the idea that should be instilled in employees' minds, and it shouldn't also be instilled in the in-house ER specialist or the HR personnel of the company. Yes, so cases must be dealt with on their own merits, but obviously you don't want to create an environment where employees are putting the employer to term, so to say, or holding them at their own actions that they have taken. Because as you said, that word goes out.
Very fast.
People talk, yeah.
Very, very fast. I actually like what you said, that because there are other employers that I know, well, that I heard of, who would, they would just fire people, go to CCMA and pay. That is the business strategy. Is you do something wrong, I fire you, not dismiss. I fire you.
Yes, I get the difference.
American style.
Yeah.
Then post firing you, we go to CCMA, I pay you out. And it's a consistent thing that they do, which creates that expectation from all other employees that if I want to, coin it, I can just come in late. Then I know that I'll be fired. Then I'm going to go to CCMA. Then it means that you'll spend whenever an employee feels like they want money, they just drag you to the CCMA.
Yes.
All the time. So,
So that's very counterproductive, and it's not good business practice or very strategic business practice to always fire and then go to the CCMA to pay out and start the process of sourcing and recruiting new talents.
yes.
And, it really doesn't speak to smooth business operations, if you are to put it that way.
I get you.
Yes.
So tell me then, when should employers take a firm stance and say, you know what, this case, we have to fight. We're going to fight it in the CCMA. Even if we lose, we'll take it to the highest court.
Well, I don't want to say a clear-cut case. I don't believe in it. Like, people view cases from a different lens or a different perspective.
Yes.
I may come to you and say, look, I have this case, I'm going to the CCMA, I'm very confident that we're going to win this one, and then you just point out, but what happened here?
Yeah.
Yeah, so I don't want to say that employers must take a firm stance in fighting cases because they are confident that the case is clear-cut, because you don't know what the employer or their representative might come and present as new evidence if they do, because they will be allowed to. It's de novo, so the case starts afresh. So I would honestly say from my experience that you must go throughout the entire process, let the process unfold. When you are invited by the commissioner to enter into conciliation and attempt to find each other, go through that process and see if you can get the best possible outcome without wasting too much time and and obviously saving as much cost as you possibly can. If that process fails because you're not held at gunpoint to settle, if that process fails, then the matter would obviously move to arbitration, and you would then arbitrate and present your case the best way you possibly can, showing that the dismissal was fair, if you are dealing with an unfair dismissal case.
Of course. And what common mistakes do most companies make when they approach conciliation?
The most common mistake would be to not entertain the idea of attempting to resolve the matter amicably. And then see, people would usually think that this is taking out money. But there are many other ways in which you can resolve a matter amicably, which does not have to deal with any monetary compensation. Yes.
I'm sure there are young, graduates in labor law, labor relations, and new professionals in the field. What advice would you give them to help them become better citizens of this country, better advisors to executives, and better people in overall in this field?
Yes. So, as a recent graduate or a school leaver entering the industry, the first step would be to understand the role and the importance of that role in an organization.
Yes.
Human resources is a very broad space.
Yeah.
And in this space, you find a whole lot of professionals.
Yes.
And specialists, industrial relations, human resources, organizational development specialists, remuneration and benefits. But at the end of the day, each and every one of these specialists have a role to play in the furtherance of the organization's goals and objectives.
Yes.
And the role that you as an HR practitioner is to play in the company is a neutral role, ensuring a smooth relationship between the employer and the employee, and ensuring that both interests are protected. So when you are faced with a dispute internally in the workplace, you ought to know what to advise the employer and what to advise the employee on the correct process to follow, ensuring that it is in line with applicable legislation, and ensuring that it is in line with the current jurisprudential climates of labor relations, being your amendments to bills and acts, your recent legal authority and case law, and really ensuring that there is an effective relationship between these two role players, the employer and the employee, and actually enforcing and applying the principles of labor relations in a fair and effective manner.
Very interesting. So, essentially, I'm going to sum up what you said. Going to the CCMA or the bargaining council, or even in the workplace, with the mindset of we are not settling, we will not settle, is not the right way, is not the right step to take, or the right decision to make, or even the right strategy at all when you're setting up your human resources or your business strategy, including your budget. Sometimes you must have a little budget for such instances where you need to settle the matter, because obviously where there's people, there'll always be problems. And also the fact that winning is not the ultimate goal. The ultimate winners are the ones where both parties can live happily, can understand and agree. If you were to go and fight a case and you win the case, and the commissioner or the judge make a ruling that indeed the employee was wrong, and the employee agrees that I did it and I was wrong, even with that, the employee will be satisfied that, you know what, I fought and now I concede that I was wrong. And I'm dismissed and it's fine and it's fair.
Yes.
Right. So One last thing, one last question for the employers.
Yes.
This is for our clients, listeners,
Yes.
and viewers. What advice would you give them with regards to work, labor relations within the workplace? Maybe if you can focus on things that they mostly overlook that can help to build a sustainable, successful, and a reputable organization.
Yes. Right. So my advice would be meaningful engagement with your workforce, ensuring that you don't adopt an authoritative approach, but ensuring that your employees understand what is expected of them.
Yes.
From a discipline point of view and a performance point of view, and ensuring that the employees have confidence in you as the employer to have their interests at heart, so that they can reciprocate that and ensure that they have your interests at heart as the employer, and not to haphazardly apply discipline or performance measures when dealing with your employees, but rather to create an environment where employees again are confident to excel, to better and further their livelihoods, which would in turn further the interests and the objectives of the business which you are running, and that would basically be healthy employee relations, because it's not just about you did this, so now I'm disciplining you or I'm firing you. But
Yes.
employee relations is much broader than that. It's essentially trying to solidify the relationship between the employer and the employee, and ensure that there's smooth interaction between the two.
Sifiso, thank you very much. Your contribution was very insightful, and I'm sure that our viewers and listeners, they will enjoy this episode. By the way, everybody, this is our first episode of the Sisol Workforce Talk, and today we had our guest. You heard him, very intelligent, Sifiso Dlungele, a labor relations specialist, lawyer by by education. And yeah, thank you for listening. We'll see you in the next episode. Please don't forget to subscribe, don't forget to follow us, and also don't forget to share. We appreciate you. Peace.